Okay, welcome back to the Daly Black podcast called The Brainstorm. Sitting here with one of the founding partners of Daly Black, John Black himself. Welcome.
Thanks.
Thank you for being here.
Be on our show.
So I want to talk about the case that everybody's been talking about recently, which is Costello v. United of Omaha.
Yep.
$113.84 million verdict.
Something like that.
I think this case has been on docket for, 17, 18 years?
So 18 years-ish.
Okay.
She died in July of 2003, and then they filed a lawsuit not long after that. It's a long time.
What's the bird's eye view, 30,000 feet up view of what is this case about? What happened?
So 30,000 feet, she buys a life insurance policy, $500,000 face value, and they do a medical exam. They figure out that her health isn't great. She's a smoker.
Okay.
They realize the risk. They double the premium. Right?
Okay.
She pays it, and then within a year, she dies. And instead of paying the death benefit, they decide to conduct a kind of full post-mortem underwriting, which they should have done in the front end.
Right.
And as part of that, they decide that she has lied on her application about her health condition. They claim that she didn't disclose high blood pressure, that she didn't disclose her heart disease, and so they denied the claim. And the short version of our case was, that's bullshit.
Right.
We sued him for breach of contract, insurance code violations, and bad faith.
Now, one question that I had is, how does a case even sit on the docket for 17, 18 years? From a layman's perspective, there's got to be statute of limitations issues. How does that end up happening where a case is sitting that long?
So there are no limitations issues, and the case got filed relatively quickly. But how does a case sit for, 17 years? I have no freaking idea, honestly.
Okay.
We got hired on this case about 6 to 8 months ago. And when we took the file over from a lawyer in Beaumont, really good lawyer named Stephen Taggart, total mystery to me as to why it had gone on so long. I mean, there were trial continuances for every reason imaginable. There were appeals, there were motions. But even with all that, I don't know why it took so long. But Mutual of Omaha fought at every turn, and they were intent on dragging it out. Even as recently as 1 week before the trial, their lawyer was asking for a last-second continuance for vacation and filing late vacation letters, and the court finally was like, this thing's going to trial.
Right.
Thank God.
Why do you think Stephen Taggart, why didn't he keep the case? Why did it end up bouncing from him to us?
So he told me that this case lasted half of the 34 years of his marriage. And he retired from the practice of law last year and just wants to enjoy his life.
Yeah.
And he turned the case over to us, said, I know you guys are really good trial lawyers, handle insurance cases, among others. And so he entrusted it with us and was hoping to go out with a bang. I mean, this is his last case, and thankfully he went out on a great note.
Did he personally reach out to you after the verdict?
So I insisted that he be at trial. And
Okay.
He was with us, and I made sure that he sat at counsel table for my closing. And he's a hell of a lawyer. He worked up the case really well, and he put up with a lot of bullshit.
Yeah.
For many years. And so he was thrilled. I mean,
Yeah.
we didn't take long in getting to a little bar in Beaumont called The Hole.
Yeah.
And he was throwing them back with everybody else at age 71.
Oh, there you
But
go.
as we speak, I think he's in Montana traveling. So
Okay, good deal.
He's enjoying it.
So I'm obviously more well-versed in property insurance as opposed to life insurance. And I
Right.
know that the name of the game for insurance companies is delay as long as you can. Hopefully the policyholder gets fed up and either takes the initial offer or they just get fed up and says, all right, screw this whole thing altogether. Does that translate to life insurance as well? Is that exactly what United of Omaha was trying to do?
It does. You see it not as frequently
Okay.
in life insurance cases because, pretty clear if somebody dies, the death benefit's owed.
Yeah.
And so there are very few life insurance companies that will try to cheat their way out of it. But I will say that as a general matter, unfortunately, not all, but some life insurance and other insurance companies have as a business model, finding ways to delay or underpay claims. And that's
Right.
just how they make and save money.
So, I mean, you touched on this a little bit, but what were the main arguments from each side? Obviously, you guys said that one of the spouses died due to the life insurance policy.
Right.
And you mentioned that they said that she was a smoker, had heart conditions. Was that their defense? What was their main argument?
So their main defense was that on the jury questionnaire, the jury had to answer 10 questions,
Okay.
liability and damages. The other side had one question, and it was simply whether or not she had lied. The legal standard is whether or not she'd made a representation that they relied on with the intent to deceive. And so their real defense was she intended to trick the insurance company, and they relied on what she told them, which is total bullshit. Our case was simple. She died.
Right.
They owe the money, and all of the reasons that they're coming up with to not pay are made up. And, we pointed out that the insurance company did its own due diligence, took its own medical exam of her, doubled the premium, knowing the risk. And then when they came back after the fact and said, hey, we're not paying the death benefit because she lied about her high blood pressure and her heart disease, we pointed out two things. One, you took her blood pressure as part of a medical exam.
Right.
You knew what it was.
Yeah.
It was elevated.
Yeah, exactly.
And then we pointed out that the only doctor that they brought to trial testified under oath that she did not have coronary artery disease. And he was on the stand for about 6 minutes and said, hey, I never told this woman that she had heart disease or coronary artery disease. And so I think the jury rightfully saw just the bullshit that we put up with and that Johnny Costello put up with. You know what I mean? You spend 17 years to get into court to hear an insurance company's defense. They had 2 witnesses, and I think they were collectively on the stand less than 20 minutes.
Oh my gosh.
It was ridiculous.
For them to hold out for 17 years and then have people on the stand for 20 minutes, it's kind of like, are y'all laying down and waving the white flag, or what's going on?
It was, not a criticism of the lawyers, but
Sure.
I mean, this is the best Mutual of Omaha could come up with at trial in front of a jury after almost 2 decades. I mean, it's shameful, truly. But more to the point, the law requires, in order for them to escape liability on a life insurance policy, they have to prove that not only did they rely on what she said, but that she intended to deceive them. And what was crazy was, the underwriter for the insurance company who I cross-examined admitted, I don't think she intended to deceive. The agent that I cross-examined that works for Mutual of Omaha said, I don't think she intended to deceive. I mean, they literally didn't have a single witness that could come in and say, we think she lied. I mean, this is a woman that had never been in trouble with the law, had never been arrested, had never filed a lawsuit, her treating doctor that came and testified for 5 minutes was like, she's an honest woman. Johnny Costello put it best when he said, look, this case for me is about clearing her name. They've called her a liar. And the insurance company accused her of that. That was really their defense. And they just didn't have any evidence to support it.
What was the demeanor like for the defense counsel, or just in general? Like, paint the picture for me in the courtroom. Did you get the interpretation that they thought that they could win this case?
Ken Adams defended them, and he's a friend, and he's a fine lawyer, and I think that lawyers don't always get to pick the facts.
Okay.
Right? All trial lawyers have had cases where they wish the facts were different.
Sure.
And, I'd like to think that, although he never told me this, that he deep down, knows he's kind of on the wrong side of the facts. And so the demeanor of the Mutual of Omaha witnesses is what was more telling. They drink their own Kool-Aid. They truly believe their own bullshit. And, you had witnesses from Nebraska that, really thought in hindsight that they did everything right, that this is the right result. And, you got a jury in the box of 12 unbiased people that are furious, that are one vote away from giving $1.1 billion. But the witnesses from Mutual of Omaha it's like they're blind, no self-awareness. They don't see the anger and just the poor behavior on their part, and they can't own it.
Right.
There was one moment of candor where the Mutual of Omaha underwriter admitted to me on cross that he had made at least one mistake in the case, that he had issued the original policy as a non-smoking policy.
Okay.
Which he shouldn't have done because she checked yes to being a smoker.
Okay.
Smoking was detected in her blood work. And I was like, well, why would you give her a non-smoking policy if she honestly told you she's a smoker? Oh, that was a mistake. Right? Okay. And so at the end of my cross-examination, I went back to him and I said, I've walked you through all these other errors that you guys have committed, all these other things you could have done. Are there any other mistakes that you think you made? And he's like, no. And look, he'd been at the company 21 years. He's still there. I mean, this might as well be an interview for him while he's on the stand. So he knows he's got to perform, but he's under oath. They know they screwed up, and their failure to own it is what caused the jury to get so mad.
And that brings another question to mind where, talking about the numbers briefly, pre-trial, the insurance company's offer to settle was $0. They essentially didn't have an offer. Our offer was $1 million, correct?
Yeah, so I had a conversation with Kent before the trial because, if I'm going to invest time to get ready for a trial like I did, once I've kind of done that, the price of poker goes up. I'm not going to settle the case
for what you could have walked out the door with months and months, if not years ago.
You get it. And that's our, Rick and I have had that approach here at the firm since we started. So there had been, I think, an offer in the low six figures, maybe $100,000 to the prior lawyer.
Okay.
I don't know the details, but when we took the case over, I talked to Kent and said, look, is it worth talking about settlement? And yeah, it's always worth talking about. And I said, look, I think that this case should settle in the seven figures. I said, and I hinted very strongly as a lawyer knows how to do that $1.5 million to $1.7 million was kind of the number that I thought was an appropriate risk amount for the case.
Right.
And he said that he would put it in a letter to Mutual of Omaha, and that if he could get any authority, that he'd talk to me on Friday. Well, we started trial Monday. I never got an offer. I never got even a dialogue from him about resolution. I mean, I think he and Mutual of Omaha have thought that this is a case that they're going to win on appeal, and it almost felt like they were trying the case with that in mind. And I'm going to tell you, I mean, you don't play a Super Bowl thinking about next year's Super Bowl.
Right.
We plan on winning the appeal, but
Absolutely.
when we go into trial, we plan on winning the trial too.
Right.
I don't think they had that view.
So for those of us who are watching that might not understand how, you can jump from what should have been a $500,000 payment to what is now $113 million, which could have been $1.1 billion, like that's such a huge discrepancy. So how do you make those jumps? How do you get to a $113 million figure from what should have been $500,000?
So the short answer is really shitty conduct on the part of a defendant here, Mutual of Omaha. The jury doesn't get to decide what the final judgment is or what the final amount we get is. The court does that. Their verdict is just them filling out numbers that they think are appropriate for each element of damage. And so most of what we were awarded, $100 million of it, were punitive or exemplary damages.
Okay.
But what the jury did was, and they were smart to do that, was they went through the other elements of damage and they put big numbers there too. They gave us the $500,000. That's an easy number to fill in, right?
Sure.
But then they gave, based on the evidence, they gave Johnny Costello mental anguish damages in the millions for past mental anguish and then future mental anguish. Because what they heard was, a man on the stand that's dying of cancer, that is taking 27, 26 medications a day just to stay alive.
Wow.
That fought for 17 years to preserve the memory of his, 34-year of marriage wife and their 5 kids and her legacy. And so they put big numbers on mental anguish because they heard the story. Then we asked for attorney's fees of about $1.4 million or $1.3 million. And it's the first time in my 20 years of practice that I've had a jury come back and say, no, we think your rates are too low. We're going to give you more. They actually gave us about $1.7 million. I never even heard of that happening from a jury.
Right.
And then they gave us findings, yes answers to bad faith, to conduct that under the law gives us and allows us to collect 23% interest on the amounts that they're awarding us. So if you take any amount, anyone that's had, high credit card debt knows, and I certainly was that guy in half of my life, 23% interest adds up fast.
Yeah.
And if you're talking about millions of dollars, I mean, the interest alone on this case is in the millions, right? Based on just the amount of time it's dragged on, right?
Right.
So, I mean, you get, you're at almost, I can't remember the math, but you're at 8 figures before you even get to exemplary damages in this case. And then what you do is you take the $100 million, right, that they award, and then you reduce it because you're only entitled to a multiplier, the actuals, right, in terms of your exemplary. So that'll get carved back, and the final judgment will probably be, I haven't looked at it or signed off on it yet, but it looks like it'll be between 25 and 30 million bucks, and that's what we ask the court to sign off on because that's what we know on appeal we can preserve and we can hold on to. But the benefit of a verdict that size and the intention of the jury here was pretty clear. Send a message.
Absolutely.
Send a message that insurance companies don't get to treat policyholders this way.
Right.
And I'm grateful that they sent it. It
Absolutely.
takes some courage, man.
It's kind of reminds me of like in a criminal case how someone would maybe get like 6 life sentences, right? It's like obviously that doesn't make logical sense, but it's to the degree of grossness.
That's exactly right. I was kind of a Greek mythology nerd, still am.
Okay.
And in the law, there's always a image of Lady Justice. Actually, Themis was the goddess of justice. And she's wearing a blindfold. She has the scales of justice. And people always talk about the scales of justice and how you got to balance and to see which side wins. And then, of course, the blindfold that is a symbol of her impartiality.
Yep.
But the symbolism that people rarely talk about when looking at Themis is her sword. She's holding a sword, and it's not sheathed. It's out in the open. And the reason that she's holding it out in the open is it is a message. It is symbolic of the notion that justice sometimes is swift and violent. And what I asked the jury to do in closing was there are rare cases where it's appropriate to take the sword and to swing it hard. And I asked them to do it here. And the presiding juror after the trial said, I hope that was swift and hard enough.
I love that.
And I said it was.
Yeah, for sure.
Yeah, it's not every case where that result is appropriate or where exemplary damages are appropriate. In fact, many cases I've tried, I haven't even asked for them.
Right.
Sometimes it's just a breach of contract. It can be just a mistake that the insurance company made, and that's okay.
Yeah.
Good lawyers, shouldn't always ask for the jury to swing the sword. But when you're right and you have the facts on your side, as we did here, juries know what to do with it.
Now, this case was tried in Jefferson County.
It was.
And I know that there was a historical perspective in Jefferson County that a lot of times jurors would kind of throw the book at bigger entities such as insurance companies. Did you find that to be a factor in this case, or is that kind of an older method of thinking or method of acting in terms of someone from that county?
I think that's a great question. I think that's an older version of Jefferson County. It definitely used to be one of the Texans for Lawsuit Reform would call it one of the judicial hellholes, one of the places plaintiff lawyers file cases to get big verdicts. But the reality is that you've got a far more conservative element in Texas, and particularly in East Texas and Beaumont, that is reflective of smaller damage awards, no liability findings, even more conservative courts. The Beaumont Court of Appeals is predominantly conservative, and that's a reflection of our state. And I try to avoid politics as a lawyer. I'm trying a case to people. I mean, politics are going to be what they are. But when I selected the jury, I was very mindful of the fact that, Donald Trump, was a very popular president in that part of the state. And, folks that, support him are not necessarily ready to hand out big damage awards to plaintiffs and plaintiff lawyers. And that's okay. What you've got to find are people that are really objective, really unbiased, and can put politics aside. Jefferson County is a really conservative and different place than it was, 20 years ago when I was going through law school.
Got you. Now, I think that for a lawyer, any case, big or small, winning a jury trial is probably one of the coolest feelings ever, I'd imagine. Now, you have a case where it's an extraordinarily high verdict.
Yeah.
You won the trial. And then also the facts are almost like you talk about them enough. And I feel like I could sit here and start crying right now just based on the egregiousness, what that man was going through. So in a situation like that, at the end of the trial, it's got to be sensory overload. Like, will you walk me through what you were thinking towards the end of that? Is there any way to put it into words?
So I got emotional when my children were born. I got emotional when I crossed the finish line at Kona Ironman, and
Sure.
I got emotional when that verdict was read, and that's not the first time I felt that. When you try a case, especially as a plaintiff, even as a partner financially, you take on the story, you take on the responsibility of telling the story for somebody, your client, and I represent people usually, or businesses that have been hurt, and so telling their story in trial is one of the most important days of their lives. I take that very seriously,
Right.
and so winning is badass.
Yeah.
It beats losing.
Yeah.
And every trial lawyer that's tried a lot of cases has lost a case or two.
Right.
But winning is really exciting and really euphoric, but it's also cathartic. It's also a release of all the feelings, the anger, the joy, the agony, the frustration, the pain, all of that you've endured while taking it on for the client releases. And it's a powerful feeling. And it's one of the things I love about our job and what keeps me really engaged in wanting to win in every case, because, clients come to us trusting us to tell their story better than anybody else.
Right.
And that's no small task.
So what's a takeaway for people watching from this case? What can people learn from this set of facts, from this trial, from your experiences?
Well, I guess it depends on who they are.
Who they are, exactly.
I think there are different messages for different folks. I mean, I think, one of the prevailing messages should be that, the jury system gets it right, that jurors do the right thing when facts are egregious, when a defendant, whether it's an insurance company or somebody else, really, really does wrong, they listen and they get it right. Another message should be that, even though this is a conservative state, and even though Beaumont in East Texas has become more conservative, we Texans, we're a rare breed, okay? And we have a don't fuck with us mentality.
Yep.
And we should. And when we feel like, I don't care what color, political affiliation, or how much money you make, I mean, our people in this state have a very, very strong temperament and react very violently to folks that treat us wrong.
Yeah.
And insurance companies that come, from out of state to sell their policies and then adjust their claims with desk adjusters in Omaha. If you treat us wrong, we're going to let you know.
Yeah. You're going to feel it.
I think the message that people should not get or take away, because, the question I get, especially from my daughters, they're like, does this mean you have $116 million now? The short answer is no. It'll be a while before we collect. But, the tort system, the trial system going to court is not a lottery system. It's not a process where folks get rich overnight or folks file a lawsuit and suddenly have Vegas money to go spend. It is a really hard, very complicated process that, if you have good lawyers, will yield a right result. You got to be patient, but this is truly a 1 in a billion or 1 in a million kind of case, and that's why it's that big.
Right. I don't think there's a better way to kind of not only stick it to the insurance company, because, that's kind of a byproduct, but make change in this industry.
Alex, I got to tell you, I think that's the best point, because I closed on change. I closed arguing to the jury that you got to send a message that verdicts are what change behavior. And, when you see a big verdict, what you might think is, oh my God, the lawyer got rich. Oh my God, the plaintiff, the client got rich. But what you've got to understand is laws in our country, unfortunately, more and more are made by special interest groups and groups that are funded by, whether it's big insurance or big pharma. It's not the industries that are really most concerned with us, with consumers, with people, our rights, right? Those get lost in the shuffle. And so even though lawyers are easily vilified, we're easily criticized for making money or being jerks or whatever it is, we're frequently instruments of change. We're frequently the only thing that stands between a consumer, the little guy, and a big pharmaceutical, big insurance company that really wants to steamroll us.
Right.
get rid of our rights. And so lawyers that are good and lawyers that are persistent and successful are instruments of change. And so I hope that a verdict like this got the attention of the insurance industry, and the Mutual of Omaha is back at their office saying, how can we resolve it, but how can we do it better?
Right.
Because at the end of the day, this is like rubbing a bad dog's nose in something.
Yeah.
You want them to learn, and you want them to get it so that the next time they don't do this, period.
I want to say this is probably one of the most interesting cases that I've gotten to look at.
Me too.
It's insane. And it's crazy that, like we said, it sparks change in the industry. So it makes me personally grateful to not only be able to talk to you about this type of stuff, to learn from you, but to really be a part of the culture here at this firm. And that's why part of the reason why I love being here is because we're not afraid of the fight and we embrace it.
I appreciate that. I love what I do. And a lot of lawyers don't, but I truly love what we do here and the kinds of fights we pick, and whether it's fighting an insurance company or a pharmaceutical company or a company that hurts somebody. To me, we are the voices for the folks out there that don't have the resources, that don't have the strength, that don't have the ability to tell their story and to toe the line with some of the biggest companies on the planet. And when we successfully go in and do that for somebody and get the kind of result we got on Friday,
right,
it's a game changer for me.
Absolutely. Well, if you don't have anything else to add, I think that was awesome.
Thanks. I'm excited to be on our podcast.
It was fun. It was fun. I appreciate it. And I think that a lot of people got some value from this. I don't think there's a better way to learn than stories. So
I hope so. I like telling a good story. Don't let the facts get in the way of a good story ever.
Definitely not. Thanks, Black.
All right. Thanks, Alex.